Hey guys, Kate Lincoln-Goldfinch here with Lincoln-Goldfinch Law with our weekly Tuesday Facebook Live on immigration updates. So I wanted to update you guys today on what's going on with the various immigration agencies and case processing. And then today's topic is the adjustment of status. So for when you're applying for your green card inside the United States, how do you do that without having to leave? And if once you do that, what does the process look like? How has it changed recently? As always, please go ahead and put your comments or your questions right here during the live video. I'd love to have your interaction, your participation. Please share this video with your friends and go ahead and like the video. And as always, you can put your public questions here in the comments, or if you want to speak to us privately, feel free to call the number on your screen, 512-599-8500, or you can send us a text message. We'll respond that way. We also will respond to your Facebook messages if you have a more private question that you don't want to air in public. And we are still providing free consultations virtually during the pandemic, so there's no reason not to reach out. If you are just wondering if you qualify or what something looks like, just give us a call. We're happy to help you. That's what we're here for. Great. So in the world of immigration, it's daily changes. So I could do a video every week just on immigration updates. Today I want to touch on asylum cases, court cases, adjustments of status, citizenship cases, and consular processing. So let's start with court cases. The immigration court system has extended their non-detained docket beyond August 14th. So if you have a hearing and you're not detained and it's before August 14th, you don't have to go. You don't even have to show up at the court. They will automatically reschedule your hearing. And if for detained cases, those cases are continuing. So anyone who's in immigration detention will continue to have their hearings. For people subject to MPP or the Migrant Protection Protocols, otherwise known as the Remain in Mexico program, unfortunately, those cases have been delayed indefinitely until a series of things can happen related to the pandemic and case numbers. I believe it is the Trump administration's way of blocking asylum. But I'm sorry to say that for the people stuck under the MPP program in Mexico, we don't know, the date of the extension or when the plans are to reopen. On the good news side of things, we have U.S. Citizenship and Immigration Service, or USCIS. That's the agency that processes all of our work permit applications, green card applications, citizenship applications, and they are back up and running at a slow pace. They've got a lot of safety protocols in place for their interviews, but we're starting to see some biometrics getting scheduled, which is great news because we haven't had any fingerprint appointments for 4 months. And we are starting to see some adjustment interviews and some citizenship interviews. And so far, all of ours have been going really well, have been successful. The Department of State is the agency that oversees all of the U.S. embassies and consulates around the globe. And so each consulate is reopening on their own schedule, depending on the COVID infection rates where they are located. Nothing's confirmed yet, but it's looking like, at least in Ciudad Juarez or some of the embassies and consulates with which we deal regularly, may look to start opening closer to September or October. An update on the furlough. We've talked about this in some of our live videos that, let me just make sure I have the comments pulled up, that USCIS was running out of funding. They asked Congress for more money, and Congress, if they don't pass a funding package for CIS, CIS has said they will furlough or temporarily lay off 75% of their workforce. That was slated to start next week, the first week of August, but it's been pushed back to the end of August. So that gives us a little more time. But that will have a significant impact on processing times if it happens. I mean, you can only imagine if 3/4 of the workforce are laid off in the agency that processes work permits and green cards and citizenship, it's going to have a serious processing time impact. And so this is a question we have with our clients all day long, every day, is how much time is my case going to take? And so one thing for all of us to keep in mind is we know what we had in terms of processing times pre-pandemic. but the pandemic and the furlough and the election results will also impact processing times. So the best thing I think those of us who are in the process can do is try to be flexible and not rely on a certain processing time, as frustrating as that is to have your life on hold for an immigration case. It's really difficult to gauge how long cases are going to be taking. Hi, Anna. Good morning. It's good to see you again. You know, one thing to keep in mind on immigration cases is little mistakes can delay cases. Like if a box isn't checked on a form or something's left off, that can lead to a rejection, or worse, if an important document is not included with the packet, they can reject it or they can issue a request for evidence. And so now more than ever, with the processing times up in the air, it's really important to be super careful in your filings. And also a Daca update. So Daca, the latest on Daca is last week we did a video that, you know, it looks like USCIS after the Supreme Court decision disallowed the cancellation of Daca. And then it wasn't clear that USCIS was going to start accepting Daca initial applications. Then a Maryland federal court judge ruled that specifically initial DACAs need to be accepted. So now USCIS is processing and receiving DACA initials, but it appears as though they're not adjudicating them at this time. So they're just sort of sitting in a bucket, a pending bucket, which is frustrating. I still think it's best practice to file right now to be, you know, eligible for litigation if it needs to happen, or to hopefully just get receipted and approved. But it is a personal, you know, weighing of the risk factors of losing money potentially and registering yourself with immigration when it's not 100% clear how they're going to handle those cases. Hi, Daniela. Thanks for saying hi. Vamos a discutir este tema en español a las 12. Okay, that's it for the updates. Let's talk about adjusting status. This is a very common case type for us. I think more than half of our cases are green card cases, you know, for the various ways that people can get a green card. So the first thing that I wanted to cover was the consular process versus adjustment of status. And so this is the whole concept of why someone who's applying for a green card can do so in the United States without having to leave, and why some people have to leave the country to go to the consulate to come back in. And the main difference when we're talking about a family-based green card application is whether the applicant entered with a visa or without inspection. We call it EWI, entry without inspection. It's someone who did not have a visa or permission to enter. And so if someone is entered and they're marrying a U.S. citizen, if they entered with a visa, even if their visa expired, they can adjust status and become permanent residents without leaving the country. The two other ways to do it are a parole in place, which is the program for families of immediate relatives of people who have served or are serving in the military. So if someone entered without a visa, but then they marry a veteran, for example, then they could get parole, which would essentially give them the eligibility to adjust status. There's also the 245I program, which is the law from 2001 that says that anyone who was petitioned before April 30th of 2001, regardless of how they entered the country, is eligible for adjustment. So you can sort of conceptualize it. It's a little more complicated than this, but the ways that people get to apply for the green card in the U.S. through family, or if they enter with a visa, they were petitioned before 2001, or they have an immediate relative who's serving in the military. Anyone else is going to need to do the consular process, and that's a topic for a different day, but it's a little bit longer process. You don't get a work permit. It's stressful because you have to leave the country at the end of the process, even though everything's been reviewed. You know, up until that point, it still feels very risky for people who have been living in the country for many years to all of a sudden leave to go get their green card to come back in. So we do the adjustment of status when we can. So the adjustment of status, the most common case is someone enters on a visa, let's say a tourist visa, and they marry a U.S. citizen and apply for the green card. There's also adjustments through parent-child relationships, and there can be through permanent resident spouses, and siblings, but those are a little more complicated. So today I'm really focusing on marriage-based adjustments of status. And we have a lot of people who've been coming in on a visa and maybe have been stuck here. Maybe you filed a visa extension, an I-539, because you had an ESTA stay or you entered on a tourist visa and your 6-month stay is expiring and you can't get any flights home. We've had a lot of visa extension cases in the last several months. And then maybe you decide, all right, I'm going to stay. I'm marrying a U.S. citizen and I want to stay and I want to file for an adjustment of status. So the first thing I want to say about that is when you're in a visa status and you file for an adjustment of status, your status shifts from an F1 student visa or a B1, B2 student visa holder to someone who is in pending adjustment. So if your B1, B2 or your ESTA is expiring, you don't need to worry about maintaining that legal status once you file the adjustment of status, because your status will shift. If this is your situation, I do encourage you to reach out to us and speak to us specifically about your case, because anytime someone is contemplating letting go of a status, we want to specifically guide you and advise you about that. For people who have like TPS or Daca, I always advise maintaining that status until you get the green card, because you don't want to let something go that you have. But I wouldn't say it's necessary to extend a tourist visa if you're also filing for adjustment of status. But if you're in that situation, you're trying to make that decision, just reach out to us and we'll guide you specific to your case. In the adjustment of status, this is a green card application. We have family-based cases, and we also do a lot of humanitarian adjustments. So anyone who had asylum and it's been a year, they're eligible to adjust, or if you had a U visa and it's been 3 years and you're eligible to adjust, you file the same application. The I-485 is the green card application. It comes with a filing fee that currently is $12.25. That could be going up, and it's lower for children and elderly people. So you always want to check the specific filing fee. And if you're filing a like a marriage-based adjustment of status, we call that a one-step, because there's all these forms that you file together. Primarily is the I-130 family petition and the I-485 green card, but we also file for advanced parole. We have to do the I-864, the sponsorship paperwork. Those require the new public charge application. And so that we typically will file in what's called a one-step. So the way that the case processing time works in our office is that we work together with our clients, prepare everything, put it together, and then we mail your application. And so we get a lot of questions about sponsors on the adjustment of status. The petitioner is always the sponsor and has to be earning more than 125% of the poverty guidelines to be the sole sponsor. If the petitioner is earning less, and it's like that, we're talking about like around $22,000 for a family of 2. If the petitioner is earning less, that would be the U.S. citizen spouse who's filing the petition, then you can get a joint sponsor who could be a family member, a relative, or a friend, or someone who is also willing to sponsor the applicant. And it's essentially a contract with the U.S. government that says the applicant's not going to receive public benefits while they have a green card. So it has to be someone you're close to who's willing to submit their own tax returns and check employment verification information so that they can be a sponsor. Also, since February, we've had to file the public charge form for family-based applicants. And so that is it's almost like a mortgage application for the applicant, where you list your education, your credit score, if you've had a social security number, your debts, your assets, your skills, if you've received any public benefits in the past. And so it tends to overwhelm people because they're not used to it. But I think the reason, I don't think people should worry so much about public charge. I think it was one of those sort of Trump programs that aimed to fix a problem that didn't exist, which is this nonsensical theory that immigrants are taking advantage of our public benefit system, where undocumented immigrants don't even qualify for benefits. And so it's one of these additional hurdles or burdens that's placed upon immigrant applicants. And, I think it's just more headache and hassle than anything else. So I've had a few people that are like, oh, I wanted to apply, but no, I don't want to because of the public charge. I really don't think it should scare people off. I think it's just to be aware that you've got to do more, submit more documents than you used to. And so we often, our clients will compare their cases with their friend or their family member, their relative who did the same process a year or 2 or 3 or even 6 years ago. And one thing that's always important to keep in mind in immigration is that this is a constantly shifting and moving system, and it's based upon the whims of who's in charge in Washington. And the president directs the Department of Homeland Security, which directs U.S. Citizenship and Immigration Service, which directs the field office directors, who direct the adjudicators who decide our application. So you can see it really flows down from Washington, and it'll affect what's required, how tough the interviews are, what the processing times are. And it's just a reality of immigration. So it's important to always speak to an immigration attorney, not a notario, not a friend who did a few of their friends' applications. You got to talk to an expert, especially this day and age. And we'll be very honest with you. At our firm, you can count on us for honesty about processing times, about your eligibility, the likelihood that you'll be successful. We tend not to recommend services for people who are ineligible or likely to be denied. We will tell you it's not worth it. It's not worth your investment. It's not worth the risk. So there's really, we'll tell you if you want to check in with us about it. So once you prepare all this stuff and you file it with immigration, and we submit our own check with our cases, and then we wait for it to get deposited, and that gives us the case number. We also get the receipt number at some point. It usually takes like 3 to 4 weeks to get the receipt notice back. And if you file one of those 1 steps for a family-based adjustment, you're going to get like 7 different receipt notices, because you file the 485, you file the 131, you file the 765, you file the I-130. So it's like and each of those forms has its own receipt number, but those are useful because they give you a case number where you can then register with USCIS and keep track of your case that way. I will say it's not that helpful. It's not like when you order a pizza from, Domino's has that really great app where like you can see when your pizza's in the oven. We're not at that level of service with USCIS, but you at least do get email notifications that come a little bit faster in the mail. Oh, Erin. Hi, Erin. It's so good to see you. Thank you. Thank you very much for the compliment. And then Fidel, hi Fidel, says it almost feels like when I had to apply for college. I tell many students that it's possible in Texas to go to college and pay in-state tuition, but you got to put in more work and effort than permanent residents or citizens. It's really involved. We're not going to lie to you guys. It's a hassle. It's not fun for us, and it's less fun for you. We do our best to make it as easy on you as we can, but they really are upping the ante on what's required to file an application these days. Okay, so we're at the receipt notice. So you register, you get your case number, and then you wait for your biometrics appointment. And the biometrics appointment is really important because that's what's needed to happen to process your work permit. And biometrics have been closed since March. So there's this big backlog of cases and people who are waiting on their work permits. But you have to do the biometrics unless you've already had one. They can recapture previously captured biometrics, but if you haven't ever done it before, you have to wait till you can get it done to get your work permit. And it's a short appointment. They'll just take your picture, they take your fingerprints, and it's to check your background with the U.S. Law enforcement databases to make sure you don't have an arrest history that maybe you didn't disclose in your application. And then once that's processed, you'll get your work permit in the mail at some point. Pre-pandemic, an adjustment of status took a year, and it took about 6 months for the work permit. And that could all be impacted by the things we've discussed already, like the pandemic, the furlough, and the election. So I'll be updating you on what we're seeing. So far during the pandemic, we saw actually a speed up of a lot of cases that were processed by mails, but because there were no interviews, a lot of people got put on hold for their work permits and for their final adjudication. But we are seeing those happen again. So once you get the work permit in the mail, I should have, printed out an example of it, but it's a card with your photo, and it says employment authorization document. And if we apply for advanced parole, which is travel permission, that's along the bottom. It says also eligible for travel. With travel permission, you know, I don't recommend traveling while you've got an adjustment case pending. The only people who can travel before they get the travel permit, so like the first 6 months of the case, are people with H-1B visas or L-1A or L-1B visas. Those are both employment visas that allow you to carry the visa while you're applying for a green card. I don't think travel is advisable right now for anyone, especially because of the employment visa limitations that the president has passed by executive order. So I really do think anyone who's applying for adjustment shouldn't go, but technically H's and L's can travel while the case is pending. And then everyone else has to wait until they get the travel permit to leave the country. But if you have unlawful presence, like if you overstayed a visa before you file, I would advise my clients not to travel. As much as I know so many of you want to go see your family members and you finally get this travel permit and the first thing you want to do is go see everybody that you miss. But it is risky because of the ever-changing policies. The Trump administration could revoke travel permission while you're out of the country. And so I advise my clients to only use these travel permits in the case of emergency and wait until you get your green card, until you do your Christmas trip or your family trip to see everyone that you haven't seen in so long. Back to the work permit, when you get this card, you'll get a Social Security card in the mail. We've had some glitches with that lately. I heard recently from a colleague that the San Marcos Social Security office has a number on their door that you can call to make appointments, and that's been successful for people. So that's a tip. Maybe that'll help you. And you can get your driver's license, but both the Social Security and the driver's license are going to be temporary. They're only valid. The Social Security card says it's only valid with work authorization, and the driver's license is only for a year. So it's only through the expiration of the work permit. So these are all temporary documents, but it's great because you can start working anywhere. You can drive without stressing out about it. So that it definitely makes sense to get those documents when you get the work permit if you haven't had anything in the past, knowing that you're going to have to go back when you get your green card to get a Social Security card without restrictions and a longer driver's license that lasts, I think, for 5 or 10 years. So then once you get the work permit, then you're just waiting for your interview, and you'll get an interview notice. For our clients, we get a notice, you get a notice, we call you, make sure you got it, and then we schedule a prep appointment with our legal director, Corey Hash, my law partner, and you meet with her and you prepare for your interview. And she'll do practice questions. She'll help you know how to dress, how to prepare, basically. And then you'll go to the interview, and we also accompany all of our clients to their interview. That's something that you always want to make sure you can expect from your attorney, is that you won't be sent to your interview alone. Because especially this day and age, we notice a difference in the way that the officers behave when there's an attorney in the room. So it's always a good idea these days, even on clean cases, in my opinion, to have an attorney with you at your interview. So at the interview, they'll typically, on a case that doesn't have any red flags, on a marriage-based case, they'll just go through the paperwork and ask a few questions about how you met, whether you've met each other's families, what the wedding was like, although they're not expecting that you had some big wedding with lots of people there. It's very common in immigration to marry quickly or without a lot of people involved, because part of the reason that the marriage is happening is to facilitate the immigration process. That's allowed. You can't have a fraudulent marriage that's only for immigration reasons. But if you married a little bit earlier than you might have otherwise gotten married, that's okay. So they're very used to seeing like common law marriage registrations or just, justice of the peace, like a court ceremony. That's all fine. And, you want to make sure you've provided enough evidence of good faith marriage. We'll give you guys a list when you start your case of types of evidence. But I like the official stuff. I like, lease contracts, bank statements, like joint phones, any insurance, maybe even a will, like an estate plan that names each other as beneficiaries, those sorts of things. And then there's this whole other realm of like what I call the squishy evidence, where it's like an affidavit from friends and family or photos or printouts from Facebook. You can have that stuff too, but in my experience, immigration sort of tends to like pick at that a little bit more. I mean, I remember one case where we had all this official evidence that was sufficient, but this couple really wanted to submit some letters from their friends about the validity of their marriage. And so they brought them to us. So we submitted it with the application, and we went to the interview, and the adjudicator started like scouring through the letters and like picking them apart because one of them wasn't notarized, and she was going to issue a request for evidence, which delays the case, to just get some of these letters notarized. And I said, just take out the letters. We don't need the letters. You have enough evidence in front of you without the letters. And she's like, okay, you're right. And she ended up approving the case. But ever since then, I try to only use the squishy evidence if there's not enough official evidence. And you can, file your application with what you've got and then update it later. You can bring updated documents to the interview. So it's also common for people to apply for the green card right after they get married and before they've had a chance to like commingle their lives. And it's okay. We can file what you have at the time of adjustment. The decision on whether it's a valid marriage doesn't happen until the interview, so we have a little bit of time. You always want to submit something, but it's okay to supplement at the interview. And it's very rare that they separate people and question them in separate rooms, but it happens, especially when there's a red flag, like there's a big age disparity or a big difference in religion maybe, or there's a suspicion of fraud because of a previous case. Then we'll see them take the applicant, the petitioner, and the beneficiary and interview them separately. Now, the attorney gets to be in both interviews, but they'll ask questions. It's really hard to prepare, but they'll ask questions that you would know if you live together in a valid marriage, and you wouldn't if you don't. But the questions can be like, draw a diagram of your bedroom furniture, or what color is his toothbrush, or where did you go out to eat on your last anniversary, or what are the names of all of his brothers and sisters, that sort of thing. And then they compare the answers. So the key is always to answer what you know and not guess. Like, I don't know where I went for my last anniversary with my husband. Well, I do actually, because it was during the pandemic and it was our 15th anniversary. So we just stayed home, which was very odd. But usually I don't remember that kind of thing. And so a friend of mine was doing one of these interviews at one point, and the couple gave different answers. Like, they had two favorite restaurants, and one of them said one restaurant, and the other one said the other. And they got denied because they gave different answers. So it's really important to say, I don't remember, if you don't remember. Oh, Summer, it's so good to hear from you. Thank you for always being on top of everything on our case. Thank you. We love you guys, your whole family, and Aaron. We have the best clients. You guys are awesome. Thanks for being here with me. So, I say don't stress about the interview unless there's something to worry about, and we'll prepare our clients. If there's a true suspicion, by the time you get to the interview, investigations may have already been done on you. Sometimes they'll send people out. If there's a question, they'll send people out to your house, like early in the morning, and make sure that you're both there, and do, I've heard them do some like investigations on people if they have suspicions. So a lot of times, but those cases are really delayed. I think if you're being investigated, because it takes a really long time. Anna, hi. Definitely, there's something new to learn each week. Thank you, Kate. Yeah, there is always something to talk about. I mean, I don't think most other practice areas are like this, where it's like, okay, we could, just do a weekly show on all the changes in immigration. I mean, I'm hoping that the election results in a new president, and that we get to start doing good news live updates. I mean, it has just been 4 years of bad news, and the Daca Supreme Court decision was like such a breath of fresh air. And then, of course, then the uncertainty rolled right back around. It's just been, it's been rough. I know you guys know that if you're watching this video, and hopefully hopefully we've got a light at the end of this tunnel. So at the interview, typically the officer will tell you what their decision is, that they see no problems and they're going to recommend approval, but they usually have to like enter in some more, background checks. They used to approve right then and there at the interview. You could walk out with a stamp in your passport, and it was great. So fun to celebrate, like walking out together with a green card. But now it's not quite as dramatic. They suggest that it's going to be approved, and then we check the system, the next day, and it's usually updated that it's been approved. And then the green card comes within a couple weeks, and then you can get the full-fledged Social Security card and the driver's license, and it's super fun. If you've been married for less than 2 years, when you have the interview, when you get approved, you get the conditional residency, so you get a green card for 2 years, and then at the end of 2 years or 90 days before the second anniversary, you file the I-751 for the removal of conditions, and we can do that if you're still together. We can also do it if you're not still together. So for people who are watching this who have a 2-year green card who are stressing about their status, if things are rocky, don't worry, we can help you guys. Just give us a call. And then if you're married to a U.S. citizen, you get to apply for citizenship 3 years. So it's 2 years to remove conditions, and then a year later is when you're eligible for citizenship. If you're no longer together, then it's a 5-year wait for citizenship. And definitely apply for citizenship when you can, if you qualify, because once you get citizenship, you're free to travel and live wherever you want. When you have your green card, you have to maintain your principal residence in the U.S., and so it's just more restrictive. And you can lose the status, etc. So it's a good idea to get citizenship when you can, and you can vote, which is super important. But I think you guys probably know how I feel about that. So hopefully this was helpful. We were talking about it in a team meeting last week about just the process and what it looks like, and decided that this would be useful for you guys as well. So feel free to share it with any of your friends who are in the adjustment process, and we're here to help you guys. So go ahead and comment even after the video if you have questions, or send us a message, or give us a call. The number's right there on the screen. Stacy has a question. Hi, Stacy. How long is it taking to see if your petition has been approved? It varies, Stacy, depending on what type of petition it is. So family-based petitions like an I-130 can be filed by permanent residents or by U.S. citizens. And then depending on what category it is, it goes to different offices. And so the best way to check how long it's going to take is to take your receipt notice and enter it in USCIS case processing times. And it'll tell you, actually, I'm sorry, not your receipt notice, your form type. So let's say it's an I-130. So you go to USCIS case processing times, you select I-130, and then it'll give you the field offices, or the offices that adjudicate those cases, and you select the one that's yours. And that you can typically find by receipt notice. This is not super easy, so if you have an attorney, you can just ask them to show you this, or you can give us a call. And then it'll tell you it'll say, we're processing cases from September 19th of 2019. And you'll be able to gauge, okay, my case was filed in October, so I should hear really soon. You'll be able to gauge, because they'll tell you where they are. One thing I will say is that sometimes they give you a range of processing times, and it can be very, very broad. Like on an adjustment, I think the processing times it's listed as like between 9 and 22 months. And so if you're on the outer edge of that, something is typically wrong. It's usually sort of somewhere in the middle for the processing times. But I will say, Stacy, that we're seeing in general still about a 1 year turnaround time on I-130s for both family members of permanent residents and U.S. citizens. But again, all of this will get impacted by the election, by the upcoming furlough, and by, pandemic. Everything pandemic. So I think that's all I had to share with you all for today. Thanks so much for being here with me. It's good to see all of you, and we'll talk next week. And I'll see you guys in 20 minutes for the same content in Spanish. Have a great day.